We're gonna be going live in a minute, y'all. I just got to get some things set up so we can go ahead and talk about the topic tonight. We got to get this shit, man, discussed. In the meantime, while I'm playing some music, get y'all some music playing while I get everything set up so we can navigate and move. And yeah, I think I'm gonna play some Gucci Mane tonight. You know, while I'm getting everything set up. You know, man, we got to see what the hell is going on, man. We're gonna talk about a lot of shit tonight. A lot of shit. Ghetto! All right, people, that's Gucci Man. Ghetto. We're going to talk about some shit tonight. We got to get some shit discussed. I'm getting too many people from all over just calling me about the shit that these damn so-called police officers are doing. And we're going to go into who they are and why we need to, man, start enforcing the law, because this shit is getting out of hand. These so-called mayors ain't doing shit. These so-called governors ain't doing shit. These so-called attorney generals ain't doing shit. Ain't nobody doing shit. The citizens are still dead to the motherfucker, still participating in their own corporate chattel, collateral reward, enslavement. If y'all can hear me, man, type yes. I want to make sure y'all can hear me. Just type yes real quick for me. If y'all can hear me, man, type yes real quick. So that way y'all know. Just give me a yes. Anybody type yes. Want to make sure. Good die. Okay. Can y'all see the screen? I want to make sure y'all can look at what I have up. Can y'all see the screen? Type I see the screen. Anybody type I see the screen. Somebody type I see the screen. It seems to be a delay from me talking to y'all and y'all actually responding back. Just type yet I see the screen. I just need y'all to type I see the screen. Anybody? Okay, good job. All right, we getting ready to get off into it. Let me put this damn phone on vibrate for messages and phone calls start coming in. And we finna get down to the meat and potatoes on this shit, man. Put the money on the motherfucking wood and make the bed good. Y'all know how we do it. All right. Number one, these bastards are not officers of the law. They are policy enforcers. And tonight what we're going to do is we're going to go in. I'm going to show y'all some things. Number one being why they are not officers of said law. This is imperative. Let's take a look. We're finna go through some cities. All right? Watch this. This is Little Rock. What do y'all see? Y'all see that shit? You see it? All right. Y'all see that? Okay. All right. We're going to go to another one. Y'all see where this is? City of Little Rock. Here's another one. Hold on. Here we go. Just right here. You see this? Y'all see that? Okay. We're going to create quite a few cities to show y'all that this shit is a universal de facto colorable requirement. All right. Hold on. We just gonna get to the meat and potatoes, man, so I can just get straight to it. All right. Perspective. Sacramento Police Department recruits must meet specific eligibility requirements, which include having a high school diploma or GED, having a valid California driver's license, being at least 21 years old upon graduation from the police academy, and being a, you see it just like I do. All right. You see it just like I do. Okay. Let me show you this. LAPD. You see it just like me. We finna get to the fucking meat and potatoes of this shit because I'm sick and tired of these bastards. We're gonna hunt some shit down tonight. We're gonna hunt some shit down tonight. Let's see. Let's see. Let's see. Right there. You see it here? And you see it there. Y'all see this shit? All right. Let's come on out of here. Gonna get off of their ass like an animal. You see it right there? Y'all see this? All right. You see it? You see it? Look at this. You see that? Y'all see that? This tells you where it's at. Connecticut. Look at this. All right. I'm going to do about 3 more, then we're going to move on. Let's go here. Criminal justice degree schools, Oakland Police Department. We'll go here. Hold on. There you go. You see it? Here we go. Y'all gotta excuse me on this because some of these cities I don't visit, so shit. Indianapolis. All right. Let's see what Indianapolis say. Applicant to the Indiana Metropolitan Department must be a U.S. resident between the ages of 21 to 35. U.S. resident. You already know what a resident is. Now, that's what we're going to do. Let's get a little bit more in-depth research. Because a lot of times they like to try to hide this shit. Oh, here we go. How to become a police officer in Indiana. Boom. 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 You see what it says? All right. So we done covered to the south. We done covered up on the northeast. Let's go to fucking New York. We done covered down south. We done covered the West Coast. We done covered the Midwest. Y'all still with me? Y'all ain't going to sleep on me, are you? You found it. Adonis Granderson, we already know that you don't have to be a citizen to work at Walmart or whatever you ask. We understand that. We talking about our people out here, man, who are having trouble, man, with these Roman centurions. That's what we talking about. I ain't got time for the fuckery today, bro. Too many our people suffering. I ain't got time for the fuckery. Bam. You see it yourself. All right, people. Let's get into the meat and fucking potatoes of this shit. All righty. Anybody coming with that foolishness and fuckery on the timeline, their ass is getting blocked and deleted. I ain't got time for it today, man. Move your ass like sassafras. We ain't got time for no dumb shit. Let's talk about this shit. Y'all see it. Just sit back and watch, man. Don't come on and ask a bunch of questions. Just sit back and watch. All righty. I've been getting a lot of complaints about these people. Y'all need to start getting these documents under seal. This is why I told y'all this shit years ago. I told y'all this shit years ago. Call these people and start getting these documents under seal. They're right up there at the Library of Congress. Miss Kickerford, I think she may still work there. She's a good clerk, man. She hunts stuff down. Look, bro, I ain't got time for the dumb shit. Your ass is getting blocked and deleted. Get the fuck out of here, man. Goodbye. We ain't got time for no stupid ass shit. I ain't got time for silly niggatry, y'all. The ignorance of some people. All righty. 14th Amendment, equal protection of the law, a tool of usurpation. Y'all see who this is? Mr. Pryor. Mr. Speaker, I ask unanimous consent. Let me give you a little history on Mr. Pryor. Mr. Pryor was a representative from Arkansas at the time. I think his name was David Pryor. Let's look at who he is. All right. This is David Pryor. This is who asked for the record to be extended in 1967. All right. And I'm glad he did. Okay. Now, this is Mr. Rarick. He's the one that extended the record. Okay. January 3rd, 1967, January 3rd, 1975. All right. Louisiana. Okay. John Richard Rarick. Let's get to the record. Mr. Pryor, Mr. Speaker, I ask unanimous consent that the gentleman from Louisiana, Mr. Rarick, may extend his remarks at this point in the record and include extraneous matter. Speaker, pro tempore, is there objection to the request of the gentleman from Arkansas? There was no objection. Mr. Rarick. Mr. Speaker, arrogantly ignoring clear-cut expressions in the Constitution of the United States and declared intent of his drafters, notwithstanding, our unelected federal judges federal judges read out prohibitions of the Constitution of the United States by adopting the fuzzy head of the 14th Amendment to legislate their personal ideas, prejudices, and theories. guilt complexes, aims, and whims. Through the cooperation of intellectual educators, we have subjected ourselves to accept destructive use and meaning of words and phrases. We blindly accept new meanings and change values to alter our traditional thoughts. We have tolerantly permitted the habitual misuse of words to serve as a vehicle to abandon our foundations. Bruh, don't call in. I'm doing a class, man. What is you doing? Damn. We have tolerantly permitted the habitual misuse of words to serve as a vehicle to abandon our foundations and goals. Thus, the present use and expansion of the 14th Amendment is a sham. Serving as a crutch and hoodwink to precipitate a quasi-legal. Y'all need to look this stuff up. Let's look it up. Quasi. Seemingly, apparently, but not really. Latin. Almost, as it were. All right. Let's get a little deeper on it. It's not what I want. There we go. Second edition. Quasi. They done chopped this. I know where I'll go. Okay. Better get out and do this. Hold on, y'all. Okay. This is in the OneDrive. That link is in the OneDrive, Republics G. Let's see where we want to go. Relax, love. Okay. Got to get out a minute to open. While it's open, let's go back. Through said to precipitate a quasi-legal approach for our overthrow of the tender balances and protections of limitation found in the Constitution. But interestingly enough, the 14th Amendment, whether ratified or not, was but the expression of emotional outpouring and public sentiment following the war between the states. Its obvious purpose and intent was but to free human beings from ownership as chattel but other humans. Its aim was no more than to free the slaves. As our politically appointed federal judiciary proceeds down their chosen path of chaotic departure from the people's government by substituting their personal law rationalized under the 14th Amendment, their actions and verbiage brand them and their team as secessionists, rebels with pens instead of guns, seeking to divide our union. They must be stopped. Public opinion must be aroused. The union must and shall be preserved. Mr. Speaker, I ask to include in record, following my remarks, House Concurrent Resolution 208 of the Louisiana Legislature urging this Congress to declare the 14th Amendment illegal. Also, I include in the record an informative and well-annotated treatise on the illegality of the 14th Amendment, the play tour of our secessionist judges, which has been prepared by Judge Leander H. Perez of Louisiana. All right, I'm going to read this. I'm going to read the first piece, or the title of the first piece coming up out of it. You can find this in the OneDrive. Y'all saw where I went. It's under Project WOM Code. It's under Pure 14th Amendment Study. All right. Okay. Then I'm going to go to the next document in this. Whereas the purported 14th Amendment to the United States Constitution was never lawfully adopted in accordance with the requirements of the United States Constitution because 11 states of the Union were deprived of their equal suffrage in the Senate in violation of Article 5. 11 southern states, included Louisiana, were excluded from deliberation and decision in the adoption of the joint resolution opposing said 14th Amendment. Said resolution was not presented to the President of the United States in order that the same should take effect as required by Article 1, Section 7. The proposed amendment was not ratified by 3/4 of the states, but to the contrary, 15 states of the then 37 states of the Union rejected the proposed 14th Amendment between the dates of its submission to the dates by the Secretary of State on June 16, 1866 and March 24, 1868, thereby nullifying said resolution and making it impossible for ratification by the constitutionality required 3/4 of such states. Said southern states, which were denied their equal suffrage in the Senate, have been recognized by proclamations of the President of the United States to have duly constituted governments with all the powers which belong to free states of the Union. The legislature of the 7 of said southern states had ratified the 13th Amendment, which would have failed of ratification but for the ratification of said 7 southern states. And whereas the Reconstruction Acts of Congress unlawfully overthrew their existing governments, removed their lawfully constituted legislators by military force, replaced them with rump legislators which carried out military orders and pretended to ratify the 14th Amendment. Whereas, in spite of the fact that the Secretary of State, in his first proclamation on June 20th, 1868, expressed doubt as to whether 3/4 of the required states had ratified the 14th Amendment, Congress nevertheless adopted a resolution on July 28, 1868, unlawfully declaring that 3/4 of the states had ratified the 14th Amendment and directed the Secretary of State to so proclaim said joint resolution of Congress and the resulting proclamation of the Secretary of State included the purported ratifications of the military and force rump legislators of 10 southern states, whose lawful legislators had previously rejected said 14th Amendment, and also included purported ratifications by the legislators of the states of Ohio, New Jersey, although they had withdrawn the legislative ratification several months previously. All of which proves absolutely that said 14th Amendment was not adopted in accordance with the mandatory constitutional requirements set forth in Article 5 of the Constitution, and therefore the Constitution itself strikes with nullity the purported 14th Amendment. Now therefore be it resolved by the legislature of Louisiana, the House of Representatives, and the Senate concurring, that the legislator go on record as exposing the unconstitutionality, here we go, unconstitutionality of the 14th Amendment. You see that? Unconstitutionality of the 14th Amendment, and interpose the sovereignty of the state of Louisiana against the execution of said 14th Amendment against the state of Louisiana and its people. That the legislature of Louisiana opposes the use of the invalid 14th Amendment by the federal courts to impose further unlawful edicts and hardships on its people. All right? That the Congress of the United States be memorialized by this legislature to repeal its unlawful joint resolution of July 28, 1868. We're going to show you, I'm going to show you here in a minute, why it's not necessary for Congress to even issue a repeal. I'll show you, okay? Declaring 3/4 of the states have ratified the 14th Amendment to the United States Constitution. That the legislators of the other states of the Union be memorialized to give serious study and consideration to take similar action against the validity of the 14th Amendment and to uphold and support the Constitution of the United States, which strikes said 14th Amendment with nullity, and that copies of this resolution duly certified, together with a copy of the treatise on the unconstitutionality of the 14th Amendment by Judge L.H. Perez, be forwarded to the governors and secretaries of state of each state in the Union. So this means they all got notice. They all got notice. Not only did they get notice, they also, man, know about this shit. They know about this shit, and they're upholding a fraud. Okay? And to the secretaries of the United States Senate and House of Congress, and to the Louisiana congressional delegation, a copy hereof to be published in the congressional record. Y'all need this record under seal. Okay? Then this goes on to say, right off the bat, the 14th Amendment is unconstitutional. Y'all can read this at your own leisure. Okay? Silly ass motherfucker asked me, what do we have against it? Man, get the fuck out of here, man. Nobody got time. See, this is the type of shit I be talking about, people. These motherfuckers ain't gonna bust a grape in the Welch's factory. You know what I'm saying? They ain't here, man, trying to help our people's situation overall, but they want to act a goddamn fool, man. We got to start getting rid of them motherfuckers, man, especially the bloodline heirs, man. Get them squares out your damn circle. All right. Y'all see this? Y'all can order this record from the archives. I talk about how you can get it. You can contact Robert Hervey on Facebook. ROBERT HERV as in victory EY. Y'all need this shit, man. So now you got Georgia. You got Louisiana, who did it in 1967. You got a congressional record. And you got the state of Georgia, who issued theirs March 8th, 1957. Okay? It says, a memorial to the Congress of the United States of America, urging them to act such legislation as they deem fit to declare that the 14th and 15th Amendments to the Constitution of the United States were never validly adopted. And to further certify that the described act is on file in an official record in the archives of the state of Georgia. All right. See the seal right here. Okay. Y'all need these records under seal, man. Get them. Okay. Here we go. Resolution. Memorial to the Congress of the United States of America, urging them to enact such legislation as they may deem fit to declare that the 14th and 15th Amendments to the Constitution of the United States were never validly adopted, and that they are null and void with no effect. Whereas the state of Georgia, together with the 10 other southern states, declared to have been lately in rebellion against the United States following the termination of hostilities in 1865, met all the conditions laid down by the President of the United States in the exercise of his constitutional powers to recognize the governments of states, domestic as well as foreign, for the resumption of practical relations with the government of the United States, and at the direction of the President did elect senators and representatives to the 39th Congress of the United States as a state and states in proper constitutional relation to the United States. And whereas, when the duly elected senators and representatives appeared in the Capitol of the United States to take their seats at the time for the opening of the 39th Congress, again at the times for the openings of the 40th and 41st Congresses, hostile majorities in both houses refused to admit them to their seats in manifest violation of Article 1 and 5 of the United States Constitution. Whereas said Congresses not being constituted of senators and representatives from each state as required by the supreme law of the land, were not in constitutional contemplation anything more than private assemblages unlawfully attempting to exercise the legislative power of the United States. All right. And whereas the so-called 39 Congresses proposed to the legislators of the several states an amendment to the Constitution of the United States, known as the 14th Amendment, and the so-called 40th Congress, which proposed an amendment known as the 15th Amendment, but without lawful power to propose any amendment whatsoever to the Constitution. Whereas 2/3 of the members of the House of Representatives and of the Senate, as they should have been constituted, failed to vote for the submission of these amendments. And whereas all proceedings subsequently flowing from these invalid proposals, purporting to establish the so-called 14th and 15th Amendments as valid parts of the Constitution, were null and void. Now, these are facts. These are facts. Concur. These are facts. Conformity to actuality. Okay? And of no effect from the beginning. And whereas, furthermore, these invalid proposals were rejected by the General Assembly of the state of Georgia and 12 other southern states, as well as of sundry northern states, the so-called 39th and 40th Congresses, in flagrant disregard of the United States Constitution, by the use of military force, dissolved the duly recognized state governments in Georgia and 9 of the other southern states and set up military occupation. You see that? Military occupation or puppet state governments, which compliantly ratified the invalid proposals, thereby making, at the point of the bayonet, a mockery of Section 4, Article 4, which states, each state in the Union shall be guaranteed a Republican form of government. Go and read it. In fact, better yet, let's type it up. All right. We'll come back to that. Right here. The United States shall guarantee to every state in this union a Republican form of government. It shall take each of them against invasion and on the application of the legislator or of the executive. The legislator cannot be convened against domestic violence. That's what happened. Okay. All right. Let's get back. Article 4, Section 4 of the Constitution, guaranteeing to every state in this union a Republican form of government and guaranteeing protection to each of them against invasion. And whereas, further, the pretended ratification of the so-called 14th and 15th Amendments by Georgia and other states whose sovereign powers had been unlawfully seized by force of arms against the peace and dignity of the people of those states were necessary to give color to the claim of the so-called 40th and 41st Congresses. These so-called amendments have been ratified by 3/4 of the states. Whereas, it is a well-established principle of law that the mere lapse of time, here we go, mere lapse of time does not confirm by common acquiescence an invalidly enacted provision of law, just as it does not repeal by general disquietude a provision validly enacted. I'll see that. And whereas the continued recognition of the 14th and 15th Amendments as valid parts of the Constitution of the United States is incompatible with the present-day position of the United States as the world's champion of constitutional governments, resting upon the consent of the people given through their lawful representatives. Now, therefore, be it resolved by the General Assembly of the State of Georgia, the Congress of the United States is hereby memorialized and respectfully urged to declare that the exclusions of the Southern senators and representatives from 39th, 40th, and 41st Congresses were malignant acts of arbitrary power. Malignant acts of arbitrary power, and rendered those Congresses invalidly constituted. The forms of law within which those invalid Congresses attempted to clothe the submission of the 14th and 15th Amendments and to clothe the subsequent acts to compel unwilling states to ratify these invalidly proposed amendments, imparted no validity to these acts and amendments. You see that? And that the so-called 14th and 15th Amendments to the Constitution of the United States are null and void, and of no effect. Be it further resolved that copies of this memorial be transmitted forthwith by the Clerk of the House and the Secretary of Senate of the State of Georgia to the President of the United States, the Chief Justice of the United States, the President of the Senate, and the Speaker of the House of Representatives of Congress of the United States, and the Senators, Representatives, and the Congress from the State of Georgia. Y'all can read this. Y'all can go back over and read it. This is part of the PDF, Pure 14th Amendment Study. Okay? All right. All right. Just looking at some of your comments. All right. Okay, here we go. All right. This is part of that PDF. Constitutional law, reprinted from ruling case law. Volume 6, for law school purposes only. Hold on, I don't know what's going on here. Okay. All right, I'm gonna come back and read this. This is pertaining to 14th Amendment. Let's go here and see if we can find quasi. It's still searching, so. All right, hold on. Okay. Here we go. Quasi. Latin. As if. As it were. Analogous to. This term is used in legal phraseology to indicate that one subject resembles another with, I'm not sure what that is. It is compared, or with which it is compared, and certain characteristics. But there are also intrinsic differences between them. Okay. So, resemblance, but it's not it. It's not it. Okay. Now, it's Black's Law Dictionary, second edition. Okay. Let's get back to this PDF. This PDF was, this book was written in 1915. Okay. And I'm going to show you something. Okay. Hold on. Okay. Effect of unconstitutional statutes. Subsection 117, general principles. The general rule is that an unconstitutional statute, though having the form and name of law. Y'all probably saying, well, how is that talking about the 14th Amendment? It's talking about a statute. Wait for it. I'm going to give it to you. Having the form and name of law is in reality no law, but it's wholly void. And in legal contemplation is as inoperative as if it had never been passed. Since an unconstitutional law is void, it imposes no duties and confers no power or authority on anyone. Y'all see that? It affords protection to no one. No one is bound to obey it. No courts are bound to enforce it. This is the reason why y'all have to correct your status, and why for the last 5 years I have been pushing blood, 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 because blood is irrefutable. The rights of blood and kindred cannot be destroyed by any civil law. Once you find out who you are according to your blood, it doesn't fucking matter what the hell they have on that record, because the laws of nature, man, take a back seat to no one. Civil law and man's law and positive law and all of that shit has to take a back seat to the laws of nature. All right? Okay. Back to this. When a judgment of any court is based on the unconstitutional law, it has been said that it has no legitimate basis at all. Y'all see this? And is not to be treated as a judgment of a competent tribunal. Any court. Could that mean the Supreme Court? Let's take a look and see. Y'all see that? And it's not to shit on this man's legacy. I'm not doing that. Our people were in great turmoil back then. Y'all see that? All right. Once again, I'm not trying to shit on this man's legacy. I'm just showing you, according to law, this could not have been possible. All right. This right here was not supposed to be possible because the 14th Amendment was not ratified. This is impossible because of the illegality of the 14th Amendment. Okay, hold on. You see that? You see that? In a decision that was later nullified by the 13th and 14th Amendments. You see that? Fraud. Even after they were freed. Let's continue down. This right here. Y'all see what I'm saying? When you get a chance, go and read this case. Those who haven't read it, quite sure some of y'all have. What obligations, Rashid Morbey, Islam fam, with the obligation of contracts, nullifying constitutional statutes protection. We're going to see what it says about contracts. Hold on. Read that Dred Scott case. Now, let me show you that there. You see this? They're continuing the fraud to this day. You see that? Still to this day, they're continuing the fraud. You see that? They're continuing the fraud to this day. You can tell by looking at that woman's face. She has, quote unquote, Negro blood or Moorish blood. You see this? This is a fraud. You see this? This is a fraud. This is a fraud. This is a fraud. This is a fraud. And this is a fraud. Now, y'all may think, oh man, you're just talking about quote unquote old white guys, man. You're trying to give them the power. No, I'm going to tell you why it's a fucking fraud. Because prior to the 14th Amendment, these women wouldn't have had political power. And women's suffrage didn't come into play until the 1920s. Any amendments that were ratified after the fraud of the 14th Amendment, a fraud. Why? Because it took, quote unquote, U.S. citizens who were born after the fraud of 1868 and made U.S. citizens, according to the fraud of the 14th Amendment, who sat in Congress, who became presidents, and allowed this to happen. Women's suffrage came after the fraud of the 14th Amendment, and it took frauds to put it in place. Fraud. Now, this is fraud as well. 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 And this is fraud as well. Why? Because they're all U.S. citizens. Show me any record where they have disavowed such colorable de facto status. Any public record, I want to see it. Because I don't believe they sit de jure. I want to see a record. I don't want to hear no bullshit that, well, when you take an oath, you're not a citizen anymore. I don't want to hear that shit. That's not what 8 U.S.C. 1481 says. That is not what it says. When you start working under another government that is hostile to the de jure Republic for the United States of America, then you lose your citizenship. That's under 8 U.S.C. 1481. Now we're going to get into this. This is just the beginning of the shit that I'm going to show y'all, man. So as you see, you don't even have a damn Supreme Court. Boom, 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 boom. 14th Amendment citizens. Boom, 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 boom. Spell what? Fraud. Okay? Of what? Fraud. All right. Now, we got that shit out the way. Let's go to back. Let's get on back. It's based on an unconstitutional law. It has been said that it has no legitimate basis at all. Is not to be treated as a judgment of a competent tribunal. The courts of other states are not required to give it the full faith and credit commanded by the provisions of the United States Constitution as to the public acts, records, and judicial proceedings of other states. Okay. Non-constitutional law cannot operate to supersede any existing valid law. Dred Scott versus Sanford. Are y'all seeing that? Dred Scott is still the law of the land. And accordingly, where a clause repealing a prior law is inserted in an act, which an act is unconstitutional and void, the provision for the repeal of prior laws will fall with it and will not be permitted to operate as repealing such prior laws. A contract which rests on an unconstitutional statute is void. I hope that answered your question, brother. I hope that answered your question. Y'all see that? So y'all need to start checking these job applications, these bank applications, these student loans applications, these driver's licenses, and all of that stuff that create a quote unquote U.S. citizen. Y'all see that? I'm gonna let that hang in the air for a minute. I'm gonna let that hang in the air for a minute. And creates no obligation to be impaired by subsequent legislation, and creates no obligation to be impaired by subsequent legislation. So if they pass something after that, it doesn't matter. It's void ab initio. If they come back and say, well, that statute was unconstitutional, subsequent legislation after the fraud, it doesn't matter because it's hinged on the fraud. It's void. It's void ab initio. These general principles apply to the Constitution as well as to the laws of the several states, and so far as they are repugnant to the Constitution and laws of the United States. Y'all seen this? Y'all seen this? All right. Let's get down to the other one. Hold on. Now, this is 16th American Jurisprudence, second edition, Constitutional Law, subsection 195, August 2017. So, in 102 years, from 1915 to 2017, shit did not change. This is 2017. What I read, y'all, came from 1915. This is 2017 American Jurisprudence. General rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the date of the decision, so branding it. So you don't need a damn judge in a fake Supreme Court telling you that something is unconstitutional. If it violated the Constitution, it's void ab initio. You don't have to wait on a Supreme Court decision. I just showed you evidence with Clarence Thomas, Sotomayor, Ruth Bader Ginsburg, and the other woman, whatever her name is, that shit is not duly constituted in accordance with the Constitution. It's hinged on amendments after the illegality of the 14th Amendment and the 14th Amendment. All right? All right. Okay. An unconstitutional law, legal contemplation, is as inoperative as if it had never been passed. It never existed. And that is, it is void ab initio. I'm going to let that hang in the air for a minute. Michael Faulkner, what they're calling public is the democracy. What they're calling private is the republic. The thing about private is the republic is bankrupt and it's defunct. Yes, it exists. It's still there according to law on paper. But they have no de jure people manning it. It's like a ghost. It's like a ghost vessel. It's a ghost ship. Nobody's over there. Okay? Right now, we are under military, admiralty, corporate maritime democracy. We're under military government. We're going to go into all of this shit tonight. So I hope y'all got time. Okay? Such a statute leaves the question that it purports to settle just as it would be had the statute not been enacted. All right. Since an unconstitutional statute is unconstitutional law is void, it follows that generally the statute imposes no duties, confers no rights, creates no office, or liabilities, bestows no power or authority on anyone, affords no protection, is incapable of creating any rights or obligations. Does not allow for the granting of any relief and justifies no acts performed under it. That means no judgments. No judgments. Once a statute has been determined, is determined to be unconstitutional, No private citizen or division of the state may take any further action pursuant to its provisions. Pursuant to its provisions. Driver's licenses are pursuant to the 14th Amendment. Birth certificates are pursuant to the 14th Amendment. Certificates of live birth are pursuant to the 14th Amendment. Passports are pursuant to the 14th Amendment. Student loans, if it says U.S. citizen in the contract, 14th Amendment. Bank loans, if it says U.S. citizen, 14th Amendment. It's fraud. A contract that rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. There is no obligation. And not only that, legislation following after the contract, repealing the unconstitutionality of an unconstitutional law, the fraud in and of itself nullified the contract ab initio from the beginning. So therefore the subsequent legislation is unnecessary. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. A law contrary to the United States Constitution may not be enforced. Once a statute has been declared unconstitutional, courts thereafter have no jurisdiction over alleged violations. Courts have no courts thereafter have no jurisdiction over alleged violations. The only crime is injury to a person's body or cause of death due to negligence or mens rea, guilty mind, or damage to that person's property. Criminal intent or negligence, which causes injury. That's a crime that falls under the law, and it's the law of torts. T-O-R-T-S. Stop for a minute. Persons convicted and fined under a statute subsequently held unconstitutional may recover fines paid. I'm going to let that hang in the air for a minute. They convict you as a U.S. citizen, and you got your status correct, for the record, you can come back and sue them. You can come back and sue them. All righty. Let's get down to the meat and potatoes. Come on, man. Don't do this. Come on now, shit. All right. 39th Congress, Session 1, Resolution 4849, 1866. Let's get down to it. Come on, man. Shit. Shit is acting crazy. Man. Here we go. Joint resolution. Proposing an amendment to the Constitution of the United States. All right. If you want to know the statute of the 14th Amendment, here you go. United States Statutes at Large, 14, page 358, or 14, stat 358. There you go. Let's go back and see what page it is. So it's volume 14, page 358. You see it? Right there. All right. Be it resolved by the Senate and House of Representatives of the United States of America and Congress assembled, 2/3 of both houses concurring, that the following article be proposed to the legislators of several states as an amendment to the Constitution for the United States, which when ratified by 3/4 of said legislators shall be valid as part of the Constitution, namely Article 14, bloop, right there. Once again, that's 14, United States Statutes at Large, 14, stat 358. There you go. All right, here you go right here. All persons born or naturalized in the United States, subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they preside. Now, this is the 14th Amendment, okay? This is what the bankers are using to hold you in slavery. The validity of the public debt of the United States authorized by law, including debts incurred for payments and pensions and bounties for servicing and suppressing insurrection or rebellion, shall not be questioned. That is what the Federal Reserve is using through the democracy. The democracy to hold you in peonage, debt slavery. You're welcome, Brother Michael Faulkner. This is what they're using to hold you in slavery. Debt slavery, this right here. Now, let's go to a case. All righty. You come on out of here. Okay. We're going to come back. Now, y'all need this. Study this. Study this. Come on, man. Don't start this crap. All right. No. Hold on. There it is. Yeah, Peer 14th Amendment study. That's what you need. Okay. Come on down here. That's what it's called. For proof of unconstitutionality. That PDF, I put that PDF together for y'all, man, like last year. I sent it out. There you go. You need to start getting your documents under seal. I'll say it again. You need to start getting your documents under seal. You can buy your liquor. You can buy your weed. You can go clubbing. You can do any of that stuff. Then you can put monies or said monies towards your education. Please, Jamal or Jameer, please quit calling me. I'm on class right now trying to help these people. Stop. I'll get with you afterwards. If it's important enough, just leave a message or send me an email. Man, people don't be thinking, man. This is why I got to get away from this shit, y'all. I really do. I really do, man. I've been doing it too long, man, and people don't be using common sense. All right. Let me go here. I want y'all to check this case out. Okay. This is Perry versus the United States. I have this in the OneDrive too. 294 U.S. 330, 1935. This dealt with the United States bankruptcy and House Joint Resolution. All right, watch this. The fact that the United States may not be sued without consent or matter of procedure, which does not affect the legality and binding character of contracts. The fact that the United States may not be sued without its consent is a matter of procedure, which does not affect the legality and binding character of its contracts. Section 4 of the 14th Amendment, declaring that the validity of the public debt of the United States authorized by law shall not be questioned, is confirmatory of a fundamental principle, applying as well to bonds issued as to those issued before the adoption of the amendment, and the expression validity of the public debt embraces whatever concerns the integrity of the public debt obligations. Are y'all seeing this? This was 1935, okay? 1935. So therefore, a lot of people got fucked when the United States went bankrupt. All right. Let's look at this. Watch this. The Joint Resolution of June 5th, 1933. Insofar as it undertakes to nullify such gold clauses and obligations of the United States, it provides that such obligations shall be discharged by payment dollar for dollar in any coin or currency, which at the time of payment is legal tender for public and private debts, is unconstitutional. House Joint Resolution was unconstitutional. It was ruled unconstitutional back then in 1935. Y'all seeing this? Back then. The fact that the government's repudiation of the gold clause of the bond is unconstitutional does not entitle the plaintiff to recover more than the loss he has actually suffered, and of which he may rightfully complain. Okay? That the defendant refused to redeem the bond except for payment in $10,000 of legal tender currency, that these refusals was based on the Joint Resolution of Congress, 1933, 48, Stat 113, but that this enactment was unconstitutional as it operated to deprive plaintiff of his property without due process of law, and that by this action of defendant, he was damaged in the sum, and he gave the sum, the value of defendant's obligation, for which with interest plaintiff demanded judgment. Okay, y'all need to read this case and understand what happened. Read this. Once again, it's Perry versus United States, 294 U.S. 330, 1935. I have it in the OneDrive. It's in the law and related matters folder. All right. So, y'all already know what to do with this. Okay. What else do we need out of here? Okay. All right. I told you that the United States is a democracy. Read for yourself. Okay. It's inaugural addresses of Franklin D. Roosevelt. Okay. All right. Now, once again, y'all see who this is by. Franklin D. Roosevelt. Inaugural address, okay? All right. He tells you right here, he's already given the people notice. We do not distrust the future of essential democracy. People of the United States have not failed in their need register a mandate. They want direct, vigorous action. They advise for discipline and direction under leadership. They have made me the present instrument of their wishes. In the spirit of the gift. Spirit of the gift. Let's look at this. All right. Gift. In the spirit of the gift. The spirit, the nature of a gift. Voluntary conveyance of land or transfer of goods from one person to another, made gratuitously, not open any consideration of blood or money. Okay? Democracy came in under a gift. The people said nothing. A transfer of personal property. Remember what I told you what rights are? What rights of property. Made voluntary and without consideration. Look. All right. All righty. Let's go here and see. Right. Noun. An entitlement to something. And right is a noun. Nouns are what? Persons, places, or things. Okay? Whether the concepts like justice and due process or to ownership of property or some interest in property, real or personal. These rights include various freedoms, protections against interference with enjoyment of life and property, civil rights, voting, access to the courts, natural rights accepted by civilized society, human rights to protect people throughout the world from terror, torture, barbaric practice, and deprivation of civil rights, and profit from their labor. That's a joke. And such U.S. constitutional guarantees as the right to freedom of speech, press, religion, etc. All right. This is what y'all gifted away. Well, not y'all, but this is what the people back then in that era gifted away. They gave it to them. It's a gift. Spirit of the gift, I take it. All right. All righty. Look at this. But in the event that Congress shall fail to take one of these two courses, in the event that the national emergency is still critical, I should not evade the clear course of duty that will then confront me. This last Congress for one remaining instrument to meet the crisis, broad executive power to wage a war against the emergency. As greater the power, it will be given to me if we were in fact invaded by a foreign foe. All righty. As you can see, this is his first inaugural address. Let's go to his second inaugural address. Are y'all still with me? Type yes. Somebody still with me? Type yes. Okay. All righty. This is the second inaugural address. Can y'all still hear me? Type yes. Somebody type yes. You still hear me? Type yes. Y'all can hear me? Type yes. Screen is not moving, so I can't see any comments. I don't know what's going on. Seems like Facebook done blocked it where I can't see your comments. If anybody can hear me, man, type yes, because I can't see you. I can't see your comments. Hold on. All right. Well, I'm going to continue to go on. See what this is? Franklin D. Roosevelt, 1937. All right. 4 years have passed. I want y'all to understand. 4 years have passed now. 1933, 34, 35, 36. Now he's coming into 1937. Now, look at what he's saying. Let's get to the meat and potatoes. 4 years of new experience have not belied our historic instinct. They hold out the clear hope that government within communities, government within the states, and government of the United States can do the things the times require without yielding its democracy. When did they become a democracy? Y'all seeing this? Y'all seeing this, right? Okay. Our task in the last 4 years did not force democracy to take a holiday. All right. Nearly all of us recognize that as intricacies of human relationships increase, so power to govern them also must increase. Power to stop evil, power to do good. The essential democracy of our nation and the safety of our people depend upon, do you see this? The essential democracy. This dude is changing shit, man, right before people's very eyes, like a damn wizard, man. Like a wizard. I don't know what's going on, man. All right. The central democracy of our nation, the safety of our people depend not upon the absence of power, but upon lodging it with those whom the people can change or continue at stated intervals through an honest and free system of elections. Look at this. This dude has the nerve to say this and put this in the same sentence. Look at this dude, man. Are y'all seeing what he did? The Constitution of 1787 did not make our democracy impotent. So he already knew what he was doing. He knew he was going against the Constitution. He knew this shit. Did not make our democracy impotent. These are his words, man. Okay. In fact, in these last 4 years, we have made the exercise of all power more democratic. We have begun to bring private autocratic powers into their proper subordination to the public's government. The legend that they were invincible, above and beyond the processes of a democracy, have been shattered. They have been challenged and beaten. It says, private autocratic powers. The states and the republic were supposed to be self-governing. Let's look up autocratic. Okay. Let's look it up like this and see what comes up. Wow, that's interesting. Okay. The states, man, supposedly was have to have some form of sovereignty. But of course, they couldn't enter into separate treaties and print their own currency, print their own money. So it's more like suzerainty. But as a body within the state, if you look up Amendments 9 and 10, the state power was vested within the people. It was placed in the hands of the people, in which the people actually, man, had their own sovereignty or held a form of autocracy. Although autocracy means like a king or a queen, some form of potentate, from what this dude is doing, he's saying, man, private autocratic powers. He's pretty much saying that anybody that had any type of rule that was of some type of sovereignty, i.e. the states, it's gone now. It's done. Okay. Let's go back. Among men of goodwill, science and democracy together offer an ever richer life. This dude here, man. Ever larger satisfaction to the individual. With this change in our moral climate and our rediscovered ability to improve our economic order, we have set our feet on the road of enduring progress. Okay. But here's the challenge. Here's the challenge to our democracy. Okay. Y'all just got real quiet. Okay. But here's the challenge to our democracy. In this nation, I see tens of millions of its citizens, a substantial part of its whole population, who at the very moment are denied the greater part of what the very lowest standards of today call the necessities of life. Okay. As you can see, he's using democracy. To maintain a democracy of effort requires a vast amount of patience in dealing with differing methods, vast amount of humility. But out of the confusion of many voices rises an understanding, dominant public need. Then political leadership can voice common ideals and aid in their realization. All right, y'all see what he's saying. So he keeps talking about this. Okay, let's go to his third one. All righty. I'm just going to basically, man, whip through this and show y'all some things. I'm not going to tarry too long in this. Y'all can go and read this. They're in the OneDrive. They're also on the Project Wamco, who told you this was a democracy. As you can see, democracy. Same thing. 4 years later, 1941. All right. Now he's working on his third term. 1933, 1937, 1937 to 1941, 1941 going to 1945. Democracy. All right, let's go to his fourth inaugural address. All right. All right. Where you at, Bubba? Bam, here you go. 1945. Our Constitution of 1787 was not a perfect instrument. It is not perfect yet, but it provided a firm base upon which all manner of men of all races and colors and creeds could build our solid structure of democracy. Wow. All righty. Hold on. Let me go get some water, y'all. All righty, I'm back. This is the fourth inaugural address. All right. January 20th, 1945. So now you see, this is like 12 years. He put it in. Now, you want to know what made it official? Like a referee's whistle. Here you go. Let's go to Cantwell versus Connecticut. All right. This is the first case I researched for a long time and found this case. When did I upload this thing? April 12, 2017. I was doing some research, man, one night for some hours, trying to find the first case that actually mentioned democracy, and I'm going to tell you why. All right, Cantwell versus Connecticut. This case was passed during the Roosevelt administration, okay? His second term. All right, watch this. Watch. This is where they threw the Republic under the bus. Okay? Look at this. This is the Supreme Court. This was your last bastion of hope. Okay? This was your last bastion of hope. The legislative had already capitulated with democracy. The executive already capitulated. Supreme Court threw the Republic and its citizenry under the bus with this. Nobody protested it. Nobody challenged his change, his colorable change of the form of government from a republic to a democracy, except one person. And that was Jacob Thorgerson, representative from Montana. And they made sure they got him out of there the next election term. And this is where the Supreme Court threw you under the bus. That's why you got to come out of her, my people, and be not partaker of her ways. For Babylon's sins have reached to heaven, and God, Allah, Yahweh, Uludumariaman, have remembered her iniquities. But the people of this nation have ordained in the light of history that in spite of the probability of excesses and abuses, these liberties are, in the long view, essential to enlightened opinion and right conduct on the part of the citizens of a democracy. Once again, you see it right there. It threw you under the bus. You see it. All right. Now let's come out of there for a minute. Let's go here. Once again, that's this link right here. All right. The Project One Code, weapons of mass code of law destruction. Hold on. All right. Watch this. Want to go here? Boom. All right. Luther versus Borden. U.S. Supreme Court. 1849. All right. Okay. Here we go. States is a true lawful and republican constitution and form of government. Said state. Said charge to regulate and exercise. Okay, we're just going to go through this. As y'all can see, you see what this is. Republican. This is U.S. Supreme Court case law. Okay. We're just going to hunt through the words. You see it? You see it. Hold on. Look. Pay attention. Right there. Free, white, and 21. All right. So y'all can go and y'all can go and watch me, go back and read this. Okay. There you go. Look at this. I'm gonna let that sit there for a minute. I'm gonna let that sit there for a minute. Y'all seeing this? All right. Y'all can go back and read this case. Y'all can look it up. All right. All right. Look at this. Government is a trust. The officers of government are trustees. Both the trust and the trustees are created for the benefit of the people. Official incumbents are bound, therefore, to administer the trust, not for their own private or individual benefits, but so as to promote the prosperity of the people. This is a vital principle of a republic. This is Secretary of State Henry Clay, 1828. Okay? If a different principle prevail and the government be so administered as to gratify the passions or to promote the interests of a particular individual, the forms of free institutions may remain, but that government is essentially a monarchy. The great difference between the two forms of government is that in a republic, all power and authority in all public offices and honors emanate from the people and are exercised and held for their benefit. In the monarchy, all power and authority, all offices and honors proceed from the monarch. His interests, his caprices, and his passions influence and control the destinies of the kingdom. Influence and control the destinies of the kingdom. In a republic, the people are everything, and the particular individual nothing. In a monarchy, the monarch is everything, and the people nothing. And the true character of government is stamped not by the forms of the appointment to office alone, but by its practical operation. If in one nominally free, the chief magistrate, as soon as he is clothed with power, proceeds to exercise it so as to administer his passions and to gratify his favorites, and systematically distribute his rewards and punishments, and the application of the power of patronage with which he is invested for the good of the whole, on the principle of devotion and attachment to him, not according to the ability and fidelity with which the people are or may be served. That chief magistrate, for the time being, within the scope of his discretionary power, is in fact, if not in form, a monarch. Henry Clay, Secretary of State, Niles Weekly Register, August 15th, 1829. Mr. Clay's speech. Go and read it. All right. All right. Same with this. All right. Public Law 97-280, October 4th, 1982, 96-1211. Public Law 97-280, Joint Resolution 1983, Year of the Bible, blah, 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 blah. President. I'll let that hang in the air for a minute. Noble Draw Lee told you don't throw away your Bibles. He told you that. All right. Come out of there. Okay. Want to go to this? Want to go to about 2 more in here. All right. Let's go. Let's go. The idea of Republican form of government implies that right in an invasion of it case within the sovereignty of the United States. Y'all see this? Y'all see this? I want to make sure y'all see this. Y'all see this? Let's go to the next one. Now, of course, in this, he's talking about colorable amendments. He's talking about colorable amendments. You want to focus on the form of government that he's talking about, which is a republic. Once again, in this case, United States versus Cruikshank, 1875. Download this in the OneDrive. All right. Last thing. All right. This right here was just talking about whether they're going to set up a democracy or a republic. This is the Federalist Papers. Number 10. All right. Y'all need to read this too. But let's see what they were saying back then. It's pretty interesting. All right. Check this out. I'm gonna let this hang in the air for a minute. Tell me what you see today. Is that not what's happening today? Yes, it is that such democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths. Y'all see this? You're seeing it. It's right there. All right. Y'all can go through this stuff. It's in the OneDrive. Okay. Back over here. I got this book in the OneDrive, Historical Readings and Other Literature. You can go and read it. But I'm going to show you something. Y'all see that? Look at this. Internal Revenue Service, property taxes, eminent domain, inheritance tax, enemy of the state, taxation, Federal Reserve Bank, Federal Communications Commission, Department of Transportation, Department of Agriculture, labor camps, drafting, y'all need to read this. Department of Education. Y'all go and read that book, man. Communist Manifesto, OneDrive by Karl Marx and Friedrich Engels. Historical readings and other literature. It's in the OneDrive. All righty. I done went into the 14th Amendment. I done covered the democracy. I don't even need to get into the bankruptcy. I'll say it right here. If you want to read about the bankruptcy, here it is. All right, it's in that folder. Now, the thing about it is this. We covered about these policemen. About, man, what really can you do? What's the remedy? Remedy is this, and once again, I'm not an attorney. I'm not any of that bullshit that they play with over there. Okay? I'm just telling you what I've seen, what I've observed with people using proper documentation coupled with writs and affidavits. But your documentation must be under seal. Okay? All right. Here's the thing. What you need to do is you need to go when you have problems with these policy enforcers. You need to get their badge number, business card if they have one, which they should have it because it's part of their uniform of identification. You get all of that. Of course, you operate in an intelligent tone. You don't argue with a fool who has a gun on his hip. You don't do that. You do not jeopardize your life and the lives of those who may be with you or your children, okay? Because we're dealing with rogue bastards. All right. Get all pertinent information and you prepare your documentation. You need to call up to the Library of Congress. Have your own congressional records and down to the Georgia State Archives. You can contact Robert Hervey on Facebook. He stays in Georgia. He's been pulling the Georgia State Archives for a lot of people. And he gets them under seal. You can get his information off of the 11 steps on my website, underneath my picture, right here. Click here. All right. You can get in touch with him for the Georgia State Archives. Right here. Robert Hervey. I'm going to show them to you. Hold on. That's him. It's my little brother. Stays in Georgia. Just get in touch with him. He'll go pull it for you. You can contact him. You can hit him via his messenger. Hit him on his messenger. All right. All right. He'll go to Georgia General Assembly. He'll get this document for you. It'll be under seal. Okay. All right. Need to contact Miss Kia. She's no longer there, but that number's still the same. They'll instruct you how to get this document. Need that under seal. All right. What you'll do is, number one, since they are operating in fraud, there is no 14th Amendment. They have no lawful authority to exercise that power. I just showed y'all that in the 25-page PDF, Pure 14th Amendment study. They're operating strictly in commerce. Okay? Let's look at this. All right. Read that. Once again, you see what it is. Unless displaced by particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion. Y'all seeing where this is going? Are y'all seeing where this is going? All right, let's look that up. Okay. We'll go here. Representation refers to a statement made by a party to a contract that induces another to enter into a contract, which can be interpreted as false or untrue. Misrepresentation must be both false and fraudulent in order to make the party making it liable for damages. This is a tort. This is a tort. Let's get another definition. The contract law, the plaintiff can incur compensatory damages when the court finds the defendant has committed fraudulent misrepresentation. Courts particularly find that a defendant has committed fraudulent misrepresentation when 6 factors have been met. A representation was made. The representation was false. When made, the defendant knew that the representation was false, or that the defendant made the statement recklessly without knowledge of its truth. Fraudulent misrepresentation was made with the intention that the plaintiff rely on it. But the plaintiff did rely on the fraudulent misrepresentation. The plaintiff suffered harm as a result of the fraudulent misrepresentation. Y'all seeing this? Yes, Calimania nulla. That's exactly what I'm saying. Okay? Now, we're going to go through some of these codes. All right? I'm going to show y'all something. This is in every state. It's in every state. I'm going to show you. Arkansas. Arkansas. Okay? Let me go ahead and put this. California. I know where to go. I'll just do it like this. Here we go. We'll just do it like this. Bam. Y'all see what it is? California. Hold up. There we go. There you go. It's California Commercial Code. Same thing. California Commercial Code. All right. There you go, Ohio. I'll go to Justine. Indiana code. Okay. I need 1-103. Let me see where we at. Here we go. Indiana code. General provisions. There we go. Okay. You're trying to rewrite yours. Trying to make it hard. Let's see. Here we go. There we go. Commercial law, commercial code, provision 26-1-103. Da 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 da. Right there. All right. Let's get more recent. Florida Senate, 671. Florida. Da 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 da. Florida. Da 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 da. Mississippi. This is Texas. As you can see, texas.gov. Da 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 da. Texas. All right. This is what they're using in all day, everyday affairs, y'all. I already showed you Arkansas, Texas. Let's go to Louisiana. Louisiana laws. Okay. Hold on. Okay. They didn't adopt the entirety of this. Let's see how they upgraded it. This is Louisiana. Louisiana is a special case because they're under civil law. Their code is civil law. It's not like the rest of the so-called corporate states who follow, quote unquote, supposedly follow common law. They don't. Let's see what we find if I add this to it. This is Nebraska. I don't know too many Moors that live in Nebraska. I don't really know any Moors that live in Nebraska. But they have it somewhere. Louisiana. All right. Let's look at New York. New York. Da, 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 da. All right. Connecticut. All right. Da, 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 da. Connecticut. We're going to go to another one. Connecticut General Statutes. Oh, let's go back. Oh, Connecticut. Georgia. Boom. Georgia. All right. We've gone to Texas, Mississippi, Florida. Just check your statutes, man. New York. Oh, Illinois. We'll go to Illinois next. We went to Indiana, went to Connecticut. I'm gonna do Tennessee and I'm gonna do Illinois. Tennessee. Boom. All right. Let's go to Illinois because a lot of our Moors be having problems in Crook County. Not Cook County, but Crook County as it's called. Illinois General Assembly. Oh, see it? All right. So, this is what you're going to do. Of course, do your own due diligence on what I tell you. Don't ever take my word for it, like I always tell you. Go and do your own due diligence. What you need to do is once you get all of their information, okay, you need to have copies of those documents. You take those documents to a notary and you get certified copies. Let the notary make copies of those documents because a notary is certified, is authorized according to the statutes to make copies. You're going to do that, man, as supporting evidence to an affidavit. You need to make an affidavit of fact pursuant to police misconduct. Police misconduct. And you see what I just showed you. You just look it up, man, in the corporate states code or statutes. Sarah, damn near everywhere. All right. The ticket stands as evidence to the fraud. Okay? Citation stands as evidence to the fraud. You go to whatever police department that gave you the citation of the ticket, and you go and get a copy of their qualifications to be a police officer of that corporate municipality. If it says U.S. citizen, you already got them directly to the wrong and the fraud, and you can attach that 25-page PDF as part of your evidence. But where I showed you those documents, you get those documents under seal, you get them certified by a notary, authenticated by a notary. Okay? You do an affidavit, your evidence is going to be copies of the authenticated documents certified by the authenticated records certified by a notary, a congressional Georgia State Archives record, a downloaded copy, a printed copy from the state statute. You may go to the law library and get a copy there of the state statute showing what I just showed you, and a copy of the qualifications from the police officer department showing that he's a U.S. citizen. His contract is null and void. Neither did he have the power to execute law. And not only that, you make it known, like I said, once again, you don't argue with these damn fools, man. Just let them know that you will be filing a claim, a tort claim for fraud, misrepresentation, coercion, and duress. And you write that across the ticket as well. If they give it to you, don't drop it on the ground. Just write fraud, misrepresentation, coercion, and duress across it, and you accept it. Don't put yourself in unnecessary danger. Don't do that. Like Killer Mike said, you survive the encounter. Survive the encounter. Okay? And then what you can do is if you got a notary that's willing to do a third-party presentation or a proxy server or a third-party presenter who's not a party to the matter, you let them present your documents, and you can get somebody else attest to the fact of what you put in the envelope, what you served in the envelope, okay? And you have the police department served with a copy of that. Once you get back the proof that they received it via electronic signature receipt requested, or certified mail return receipt requested, or proxy server affidavit of serving, then what you do is you take that, you go down there, and you file this into your case, whatever it is. Once you do that, if possible. Now, me, myself, I deal strictly with the administrative process. I don't believe in dealing with their courts because I just showed you. Their courts don't exist. But to keep unnecessary danger up off of you, you go in under what they say, special appearance. You're not there to argue the matter. You're there just to get settlement on it, settlement and closure of it, because your rights were violated. And you got the evidence. Make sure you file, once again, the affidavit of fact pursuant to police misconduct, the state statute, what I just showed you under 1-103, the ticket where you wrote across it, threat, duress, coercion, and fraud, and put the state statute on there, okay? And the certified records from the Library of Congress and the Georgia State Archives with the notary certification that the notary officiated the copies made. You file all that into the case. And don't try to embarrass the administrator, because that's really what gets them acting a damn fool. They really believe they judges, but they not. I just showed you. You can't hold any office. None as a U.S. citizen. It's fraud. And you ask them, can you settle that matter privately in chambers? You ask them, can you settle it privately in chambers? Because you have information that you do not want to disturb the public. You don't want to disturb the public peace. Something in that manner. I don't really deal with that shit, but you want to settle it privately. Once he sees that, and he sees what went on, then you tell him, hey, this is a contract, man. This is a contract, because if he doesn't have the lawful power and none of y'all can sit the bench lawfully, you can't hold General Assembly in any state lawfully. It's been this way since 1868. And he forced me to contract. Well, man, we got to look at the rules of equity. And go and study them 20 equity maxims. You study them 20 equity maxims. And he has to give you honesty and fairness, because you can't exercise power in that corporate boom, boom, boom capacity as an officer of the law. No, you can't do it. So that's how you need to deal with this. These are some of the things I wanted to show y'all. Pretty much, this is what I wanted to tell y'all. This is it. Once the matter gets settled, you can go back after that so-called officer and you can sue his ass. You can sue his ass. And there's nothing else to be said about that. You can sue his ass. All righty. Let me read some of these comments, man. You're welcome, El Jordan Bay. Let your paperwork precede you. You need to get all your stuff done within 72 hours and submit it to that court. So if I were y'all, I would have something already prepared just in case an issue arises. That way, the only thing you have to do is have a notary authenticate the records and go and look up the codes. Have your affidavit already typed up just for future necessity, possible necessity. Don't wait and then try to type it up. Don't do that because time is ticking. Have you some mail numbers ready, certified mail numbers. Have somebody third party on standby. In other words, a warrior never makes a shield on the battlefield. Have your shit already in order. Have your affairs in your house in order. All right. Let me see what else going on. Okay, brother Sadat, true. They be blocking file. Yeah, Missouri. Look it up for Missouri too, Asani. Sure it's there. Sadat Bay, El Malik, they do be blocking filings. That's why you got to get your third-party servers or your notary presentment or whoever will serve it for you. Because once you got an affidavit of witness attesting to the fact of what went in the envelope and who served it, it doesn't matter if they try to block it. Because guess what? Them not allowing you to file that in the case is a denial of due process. Let's look. Life, liberty, or property without the due process of law. We're not concerned with this bullshit. That's what it is, bullshit. All right? Boom. Okay. If you got evidence, y'all see this? You got evidence against them. They have to show evidence against you where you broke the law. And not only that, that they are not under fraud, misrepresentation, committing duress and coercion. Notary presentment. Notary presentment. Third party server. Okay. All right. All right. Not a problem. Not a problem. I don't know when this thing gonna cut off. I know we've been going for a while, and I don't want it to do like last time. But these are some of the tools you can use to build onto you getting remedy. Okay, dealing with these policy enforcers. Okay, here it is. 2 hours 54 minutes. And okay, I got another hour, so I'm still not gonna keep y'all that long. Okay. So this was my community service today. If y'all wish to donate, man, y'all may do so at my website. I really appreciate the love and support. Study what I've given you tonight. Go back and take notes from this video. Okay. Do this shit. Don't just take this one night and, oh, I got it. No, you never get it. Study this shit and know this shit. Okay? Study from the sources where I gave y'all. I showed you the 14th Amendment. I showed you the democracy. If you like for me to show you case law where bankrupts are civilly dead, go to this folder. Go here. If you want to know about the bankruptcies and about the case law that talks about bankrupts being civilly dead, I gave that to y'all as well. Go here. Bank versus Sherman. I'm gonna open this up just to show y'all a couple of things. Okay? We're not gonna get too heavy off in this. Just want to show y'all a couple of things. That's all. Hold on, I need to put it down here. Okay. See that? The bankrupt became, as it were, for many purposes, civiliter mortuus. Bank versus Sherman, United States Supreme Court case, 1879. Okay. Let's go here. Carr versus Hamilton. See. Nope. Justice should notify the persons holding policies on the company become bankrupt and goes into liquidation. By that act, the company becomes civiliter mortuus. Business is brought to an absolute end. And the policy of y'all reading this shit? This is their law. That's the reason why they had to pass the case in 1938 of Erie Railroad versus Tompkins to get out from underneath the previous law they passed, and they came and threw you up underneath the democracy in 1940 with the case of Cantwell versus Connecticut, because this was the law. The United States was civilly dead. That's it. And it's still the law. It's still de jure law. Carr versus Hamilton, 1889. In 29, US 52, US Supreme Court. They wanted to get out from underneath it, man. Let me see the other one. Herndon versus Howard. This is another one. This is a previous one. Okay. Herndon versus Howard. Case. Okay. Section of the bankrupt law relied on one thing governs the present case. Here you go. To require that masters and assigning essentially the bankrupt, who may be said to be civiliter mortuus, precisely as an executive or administrator would be made party instead of appellant. Actually deceased. When corporations go bankrupt, they are civilly dead. Okay? You see this shit. Now I'm going to go into y'all can go and read it later. This is 103rd Congress, 139, 33 H 1303 to H 05. This is the congressional records. 1993. This isn't any of that stuff that some of these other people are showing you that it doesn't read like it's supposed to. No, here you go. Mr. Trafficant, Mr. Speaker, we are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the U.S. government. We are setting forth, hopefully, a blueprint for our future. There are some who say it is a coroner's report that will lead to our demise. This is not the shit you're finding on the internet. This is the real deal shit. Here you go. Congressional records, 1993. All righty. See the seal. Go and get this record. All right. Let's go to this one. This is 1992, Henry Gonzalez. Okay. National and international thievery in high places. Mr. Gonzalez. This is what his is. Y'all need to read his report. I'm gonna have to skim through this to find out where he tells you. All righty, here we go. Mr. Gonzalez says, I am asked, well, Henry, if you had your way, what would be the biggest single thing you would want? Well, it is very simple. Solvency, solvency, solvency. We are bankrupt. We are insolvent on every level of our national life, whether it is corporate, whether it is just plain you and I out here with the level of debt that we have piled up, private debt. Hold on. Credit cards and whatnot, or whether it is the government. We are insolvent. How long will it take before that nasty mega truth is conveyed? He tells you right here. Congressional record. As you can see, seal right here. See, 2016. And you can read the other congressional record. Of Louis T. McFadden, 1932. He tells you about the bankruptcy of the Treasury as well as the Federal Reserve. None of these entities have come out of bankruptcy. It's all a sham. It's all a sham. Here you go. Here's the seal. All of this is in the OneDrive. So you can go and read it. 3 bankruptcy statements. Okay. Also, if you want to read about the democracy, one man that fought against it You go here. I have these congressional records too, under seal. Okay. Y'all start using these things to defend yourself. Get them under seal. Okay. I have them in the 11 steps. Watch this. Let's look at this. Let's see. Y'all need to read this. This is some deep shit here. All right, check this out. This is what he says. I want you to note particularly that this was in 1913. That 1913 was that very year we changed our government from a republic to a semi-democracy. The year in which we destroyed constitutional government, international security, and paved the road for us to become a colony of the British Empire. It was also the same year in which we, by adopting the Federal Reserve Act, placed our treasury underneath the control and domination of the Bank of England and the international banking groups that are now financing the British Israel movement in the United States. Why do you think, man, you can't say nothing about Jews? Quote unquote, who they call Jews. All this shit is financed, man. Y'all need to read this. Look at this. Mr. Cho was therefore right because nothing has stopped, not even Congress, the destruction of this republic and its gradual incorporation into the British Empire with the efforts of many subversive and pro-English groups, led and directed, as I have said, by the British Israel movement. Y'all need to read this, man. This shit is real. So that's there for y'all too. And in the meantime, I think I've given y'all everything that that you need to research, do your own due diligence, and this is just where we at. So I'm gonna go ahead and get off here. I hope y'all enjoyed this. I hope y'all learned something. I hope y'all learned, man, how to actually deal administratively with these people. Do not deal with them in anger. Don't get upset. Don't do any of that. Okay? Deal with them, man, administratively. And y'all now have the tools to go and do your own due diligence and research it for yourself. Hell, you may even take what I've given you and build upon it and make it even way more perfect, man. So, you know, just do your thing. And in the meantime, love y'all. Peace and love. You know, and Ashe. Y'all have a peaceful and restful evening. Love y'all.